Hi everyone, मैं हूँ आपकी host and दोस्त आयुषी and welcome to Law Headline channel. Today we are going to discuss the reported judgment of Honorable Supreme Court in the case of Ajay Kumar vs Lata, Shruti and other in Criminal Appeal number 617 of 2019. This judgment is pronounced on the 8th of April 2019. In this judgment, Honorable Justice Dr. D.Y. Chandrachud and Justice Hemant Gupta decide the case law of Domestic Violence Act. So before go further, we will go through the brief fact of the case and thereafter we will go through the relevant provisions of the Act. So let's begin. The first respondent filed a petition under Section 12 of the Act inter alia for the purpose of seeking an award of maintenance. The complaint contains a recital of the fact that after her marriage, the complainant and her spouse resided at a house which constitutes ancestral Hindu joint family property. She and her husband resided on the ground floor of the residential accommodation. The appellant and the deceased spouse of the first respondent jointly carried on a business of a Kiryana store at Panipat from which, it has been alleged, each had an income of about 30,000 rupees per month. The complaint alleges that at the death of Vijay Kumar, the first respondent was pregnant and that she gave birth to a child on the 31st of January 2013. The travails of the first respondent are alleged to have commenced after the death of her spouse and she was not permitted to reside in her matrimonial home. Now we will go through the relevant section of the Domestic Violence Act which were discussed in this judgment. The expression, respondent, is defined in Section 2(q) as follows. Respondent means any adult male person who is, or has been, in a domestic relationship with the aggrieved person and against whom the aggrieved person has sought any relief under this Act. Provided that an aggrieved wife or female living in a relationship in the nature of a marriage may also file a complaint against a relative of the husband or the male partner. Section 2(f) defines the expression, domestic relationship. Domestic relationship means a relationship between two persons who live or have, at any point of time, lived together in a shared household, when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption or are family members living together as a joint family. The expression, shared household, is defined in Section 2(s) as follows. Shared household means a household where the person aggrieved lives or, at any stage has lived in a domestic relationship either singly or along with the respondent and includes such a household whether owned or tenanted either jointly by the aggrieved person and the respondent, or owned or tenanted by either of them in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title, interest or equity, and includes such a household which may belong to the joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title or interest in the shared household. After reading all the section which discussed earlier, it is clear that all these definitions indicate the width and amplitude of the intent of Parliament in creating both an obligation and a remedy in the terms of the enactment. Honorable Supreme Court held the case law that there are sufficient averments in the complaint to sustain the order for the award of interim maintenance. Paragraph 10 of the complaint prima facie indicates that the case of the complainants is that the house where the first respondent and her spouse resided belonged to a joint family. The appellant and his brother, who was the spouse of the first respondent and father of the second respondent, carried on a joint business. The appellant resided in the same household. Ultimately, whether the requirements of Section 2(f), Section 2(q) and Section 2(s) are fulfilled is a matter of evidence which will be adjudicated upon at the trial. At this stage, for the purpose of an interim order for maintenance, there was material which justifies the issuance of a direction in regard to the payment of maintenance. After perused this judgment, it is clear that the women who lived with her husband, in a joint Hindu family in share household, can demand a maintenance against his deceased husband's brother. Hope so you like the video. If you like the video, please subscribe the channel and don't forget to share and like the video. Thank you for watching the video. Have a nice day.